Good evening, all. Welcome. I'm Robert Jackson, and on behalf of New York University School of Law, welcome to an evening fireside chat with my friend and former colleague on the Biden transition, SEC Chair Gary Gensler. Gary, welcome to the NYU community. First, folks, a couple of administrative matters. I want to begin by thanking the Program on Corporate Compliance and Enforcement and my wonderful colleague, Jennifer Arlen, who is helping to bring this program to life this evening. And of course, my colleague, Ed Rock, with whom I co-direct the Institute on Corporate Governance and Finance. We are all, of course, here at NYU delighted to welcome Chair Gensler to our community and to have a fireside chat about the many crucial issues facing the SEC over the coming months. Chair Gensler, welcome.
It's good to be with you, Rob, and thank you for the invite, Ed, Jennifer, and the whole team.
Well, we're delighted to have you. And Gary, you know me, I want to get right to it. So let's get right to some of the most pressing issues that you have identified in your early days as leader of the SEC. I think the market is really at a moment of anticipation for the possibility of climate rule proposals coming soon from the SEC and its Division of Corporation Finance, and of course, your terrific director, Renee Jones. In particular, I think the market is curious, Gary, about how prescriptive those rules will be, the degree to which there will be industry-specific approaches in such a rule, and how much direct regulation versus standard setting firms should expect. I know the staff is working hard on these proposals, Chair Gensler, and we're wondering, how's that work going? What should we expect to be coming, and what should the market be thinking to prepare corporations for providing transparency on this crucial issue?
Well, there's a lot that you have in there, but I want to thank you for the question. Let me go back to the sort of the basics. There was a basic bargain all the way back from the 1930s that investors get to decide what they invest in, how much they invest, and the like, but it's based on disclosure, full and fair disclosure from the issuers. And we've updated what those disclosures are multiple times over the decades. So where we are in the 2020s is investors have been asking for and finding useful disclosures around climate risk. Hundreds of companies are making voluntary disclosures in this space. All around the globe, in fact, thousands of companies are in some way or another. And I think that's exactly where there's a role for the Securities and Exchange Commission to come in and to help achieve our multiple part mission. I'll get back to the mission in a bit, but it's basically to help bring consistent, comparable, and decision useful information to investors. Where are we? This staff is, as you know, it's a terrific staff at the SEC, but it's those people in the Division of Corporate Finance, in our Division of Economic and Risk Analysis, and our General Counsel's office are working very closely together. But this team goes across other divisions as well. Our Chief Accountant's office, even our exams and enforcement. We sort of build out these teams where the staff run out of our Division of Corporate Finance, but includes members from each of these other areas, are really looking at the economic analysis and the like. And, you know, today I think I had one meeting on climate, but it's a rare week that I don't have 2 to 4 meetings somewhere where they're briefing me or asking a question. But it's really mostly driven by this remarkable group of individuals on the team.
That makes good sense. I want to ask a quick follow-up, because one of the things that one sees in the comment letters and the many investors who've expressed an interest in getting more information on this, Gary, is the desire for some standardization, and in particular for international cooperation and harmony across markets when it comes to the details of a climate disclosure regime. What are the prospects for international cooperation in this area? Should we be expecting that to be part and parcel of the staff's work, or do you imagine that might have to come a little further down the road?
Well, I think there's been a lot of dialogue and I would say cooperation across the international community. I'm honored to be a member of the Financial Stability Board, which is a group of I think 24 jurisdictions are involved and various standard setters and the like as well. We've published even some reports while I've been a member of that group in the last 6 months. We at the SEC benefit from the work that's being done internationally to meet those investor demands. And again, everything we're doing is about investors and what do investors want to make their decisions. There's something you might know about, it goes by the letters TCFD, a task force on climate financial disclosure. And that was written up in 2017. There's many other international organizations and groups that have written up things. And so we've benefited from that, we at the SEC. So back to your question, what's the likelihood of consistency around the globe? I think we're inspired. We at the SEC are sort of looking at, inspired by those discussions around the globe. But you know, a document still needs to be written. The economic analysis has to be here, and it's the 5 commissioners here that will either put something out to public comment or send it back and have the staff work it some more. And so we really are looking at putting out proposed rules that benefit from all of that, but are still, you know, what makes sense here in under our laws and under our markets.
That makes sense. And by the way, let me emphasize, I want to say, Chair Gensler, we're now joined by more than 500 attendees. Welcome all. And I want to emphasize, as my colleague Ryan Gibson mentioned, if you have a question for the chair and you'd like to share it with us, please go ahead and put them in the Q&A, and I'll moderate and share the questions that we have time for with the chair. Gary, while we're on the subject of disclosures, of course, your agenda and your public remarks have also prioritized more transparency on human capital matters, and in particular on issues of diversity and inclusion across public company workforces and even in the executive suite. Can you tell us a little bit about what the market ought to be expecting on that front from the Commission?
Well, so if I could stay just a little step back, excuse me. Oh my God, that's one recording too. Just step back. So we have a number of disclosure projects, as you say. One that we just discussed, climate risk disclosure. Another around the workforce, which we've tended to call human capital disclosure. And a third on cyber risk and cyber disclosure. But on that middle slice, one of the most important assets of any business is its workforce, its human capital. It's as true today as it was in previous decades, but more and more when you look at businesses, it's less about the physical assets and more about the intellectual property and the workforce. And that really relates to the human capital and the cyber piece of this, some of the 2 other disclosure pieces that we're working on. In the human capital area, we're going to look to build upon what the Commission did as recently as last year, and just build upon. There was a recognition that this disclosure was relevant, was material, in the words of securities laws, to investors. But I think we can also help out investors by building in some more specificity into that, about the turnover rates, about who's part-time, how many people are full-time. And yes, as you said, potentially disclosing the diversity in those workplaces.
Makes good sense. By the way, before we leave the subject of disclosure and transparency, especially on climate, Gary, a question I've gotten a lot is, once we've got some proposed rules or some rules out there, is the Commission going to work with other entities, whether it's the PCAOB or some other accounting oversight body, on auditor standards to make sure that whatever information is coming out of these companies is assessed and audited in a consistent way across the capital markets? Have you gotten that far and you're thinking about this project, or are you not yet at the stage where you're thinking about auditor guidance?
So I wouldn't want to get ahead of the process, but as we put something out to proposal, the investing public, the issuing companies can all weigh in. And I would hope also, as you mentioned, accountants and auditors, to the extent they think they have good advice for the commission. So I really am looking forward to, in all our rulemaking, to hear from the public. But in this climate risk area, and the human capital area, it'd be really interesting to hear what investors are saying. So I do encourage you, if we do move forward with a proposal, to weigh in. Now, on this, the key part of your question about accounting and auditing, we have been in discussion with and thinking about in this phase where such disclosures would be appropriate. And there's been a little bit of a lively debate even earlier this year. Commissioner Lee, then Chair Lee, put out for comment a request for comment around these very issues around climate risk. And we got, I think it was close to 500 individual comment letters at that point in time. And many commenters said that the information should be in the annual reporting, in the 10K and the like. Some said maybe not. Some said, well, let's keep it outside and keep it just on the websites. Some said mandatory, some said voluntary. So we're sorting through those issues. But one of the things that you've just raised was about auditor assurance or attestation. And that's one I'd like not to get in front of my fellow commissioners. I mean, I can say my resting foot is more towards mandatory than voluntary, and more towards being inside the annual reports where you have some assurance that there's a control environment. And we have really for decades a certain rigor that goes into the management discussion and analysis, or the risk factors that are inside of an annual report. So
makes sense. Now, I know there's a lot of work you're doing on transparency, Gary, but let's turn to away, as one of the questioners in the audience suggested, away from the E and the S, and let's turn now to the G, shall we, and talk a little bit about your work on shareholder rights. Obviously, the commission has announced that the proxy advisor rule adopted during the last administration, and changes to Rule 14.8, the power of shareholders to bring proposals. I should say, in the interest of full transparency, that I dissented from both proposals. Now that those are on the shelf for the time being, I'm wondering, Gary, whether the commission is interested in taking up some other initiatives in this area that have had some bipartisan support. For example, universal proxy, which has drawn support from lots of different corners. Do you think something like that is on the near-term agenda for the commission?
Well, we publicly discussed earlier this year that it is on our agenda. We have something in government called a unified agenda. It's basically a list that every agency puts out as to their rulemaking priorities. And so, yes, it's on the rulemaking priorities. In fact, I guess I'll be breaking news or something. We have a draft in front of commissioners that I think gave just this week. So, this is something that's depending upon how my fellow commissioners weigh in on this staff draft, is on the near-term agenda. Now, what's the basic premise? The basic premise is there was a day when you could walk into a shareholder meeting and vote. And if there was the slate of candidates from management, and there was a slate of candidates that was offered up in competition, you could pick amongst them and vote if you were in person. But in paper form, you got a ballot mailed to you from one side and a ballot mailed on the other side, and it was frankly a bit inefficient. The concept of universal proxy is, why not put that on one electronic form, or one piece of paper, so to speak. And it really is a matter that can be efficient and promote shareholder democracy. So I think it's again, I don't want to get ahead of my fellow commissioners, but it's been on our unified agenda, and it's in front of commissioners, well, I guess as of this week.
Well, that's terrific. I suspect the market will greet that will welcome that news, Gary. I think there are a number of folks across the marketplace who've been thinking hard about universal proxy for some time. I know the process involves consulting with your fellow commissioners, so I don't want you to get ahead of it, but the idea that the staff is moving forward with that is very encouraging. Let me turn to another area that you've talked a little bit about in some of your public remarks. My old colleagues at the Wachtell Lipton firm have long pressed the SEC to make changes to the laws governing activism at U.S. public companies, in particular to shorten the 10-day disclosure window that applies to acquirers of 5% or more of the stock of a publicly traded firm. They filed a petition, a decade ago now, suggesting that the commission make that change. In addition to shortening the window, my former colleague suggested that the disclosure regime apply not only to acquisitions of stock, but also to derivative instruments that achieve similar economic ends. This has been debated back and forth for some time, Gary, and I'm wondering, putting to one side what's on the agenda, and I know some of these matters are on the agenda, what's your view about whether it's time to make some changes to that regime?
So let me put it in context for the listeners, and I know, Rob, you and I might be on different sides of this debate. Well, then again, maybe you'll want to join me. But I think that when the law was written 50 years ago, the Williams Act was written to say, basic thing, if you pass 5%, and you have an intent to influence, roughly speaking, intent to influence a company, that you disclose it. Now, guess what? In 1972, 10 days might have seemed like the appropriate time. We had just gone through the paperwork crisis of the late 1960s. The settlement cycles were 5 days at that point in time. 10 days, maybe that was, appropriate given that. And when I say paperwork crisis, like the stock exchange shut down in the late 1960s for a number of days to clear the backlog of all the documents and all the paperwork in the back office. This was pre-central clearing through DTCC and basically the digital age that we live in now. In 2010, in Dodd-Frank, Congress gave the SEC, our authority, an ability to shorten that 10 days. So I've asked staff to take a close look at this. I think that there is a basis to shorten that because shareholders from day number 1 to day number 10 are selling potentially at a price, not knowing material, non-public information that somebody who's already crossed the 5% line has a legal obligation to disclose, will disclose currently in day 10, but during those 9 days. I think shortening that, and by the way, around the globe in different regimes, it's usually a very short period. So in some regimes, just the very next day. I think that would address this basically asymmetric information that that a small group of people know that a filing's coming and they've crossed the line.
I see. Okay. And my question, I guess, is, do you think there should be different rules for different kinds of issuers? That is, do you imagine one size fits all? We're going to take this from 10 days to some number that's less than 10. Are you imagining that maybe market dynamics should drive a different treatment for different firms? For example, mid-cap and smaller cap firms where activism is much more common and where the 10-day window is an important source of returns for activists in those companies. Do you have a sense yet, Gary? Or is
I don't know if I share your premise, Rob. So it's possible that we might be a little bit different view on this. I view it through investors. I think that investors, there's an asymmetric information advantage that some small group of people know somebody's crossed the line. And the technology of 1972 is vastly different than the technology a half a century later. I mean, if this isn't ripe for reflection, and Congress gave us the authority to reflect just on common, technologies of 2021, but you raise an interesting question. Of course, I wouldn't want to get ahead of the staff. This is not like universal proxy that just went to the commissioner. So, but I do think that modern technology and Congress can allow this thing to shorten down, and then investors, if they know this information, they can decide to keep holding their stock or selling their stock, but they have that material information.
That makes sense. That makes sense. You might be right that we might think about that a little bit. Of course, something else that's changed since the 1960s is the Delaware courts have approved the poison pill. But maybe that's a debate.
That was your friends at Wachtell Lipton too in 1982 when they invented that little thing.
Yeah, that seems relevant to me to the debate, but I certainly see why folks could see that either way. And I understand. Oh, by the way, I should follow up and ask, what about derivatives? You know, Gary, there's been a lot of concern in the marketplace about, as you say, transparency, when derivatives can be and are used to establish a toehold position and may not be subject to disclosure under 13D. Is that something you got the staff looking at as well?
Yes, and I know it's a common refrain here, and for your listeners, everything has to start with our legal authorities, the economic analysis, and the remarkable staff at the SEC working through and thinking these issues through. But yes, the events of earlier this year in March of 2021, we had events around a family office that ended up failing, but that family office had used significant amount of total return swaps, basically to get the economics of underlying stocks, underlying companies. And they had entered in total return swaps with multiple broker dealers that aggregated to significant portions. So when they failed and each of those broker dealers had to sell out, you saw some disruptions in the marketplace. We have authorities at the SEC that were granted again in the reforms of Dodd-Frank around so-called securities-based swaps. Some of those go live this November. We have a whole regime where securities-based swap dealers will be registering as of November 1st, that various transactions will have to be sent to a data repository starting November, I think, 8th. And then there'll be some public reporting even in February. But I think that we ought to go further and use another set of authorities that Congress gave us back again in the Dodd-Frank reforms. And those allow us, the commission, to write rules around disclosure around securities-based swaps, large positions. It's called 10 capital B authority. And I think that the staff is working on this at this time. They'll serve up some recommendations again to our full commission, but it's around these issues about when somebody starts to aggregate what's in the statute, a large position, then to bring that to light.
That makes good sense. And while we're on the subject of corporate governance, shareholder rights, we've got a couple of questions from the audience about BlackRock's recent announcement that they are going to grant voting power to some of their underlying clients on certain shareholder proposals. One of the folks in our audience asks, what's your reaction to BlackRock's announcement? And is the SEC thinking about adopting a rule that would adopt this feature across the marketplace, that is requiring large institutional investors to take notice and maybe even give the vote to their underlying large institutional investors?
I appreciate the question from the audience, and I think it raises interesting policy choices that you're trying to raise. I'm going to say one thing that we have done, which is in this subject area, but a little bit different, is back in 2003, the SEC adopted rules that funds that manage the public's money would disclose to their investors how they voted. It was called Rule NPX. What we found over the last 18 years is that sometimes these were not easy to understand. They were not consistent. They were not, frankly, as useful as the commission in 2003 thought they might be. And so we put out to proposal just a few weeks ago a whole revision and update of Rule NPX, which would include some things that you would think in the 2020s. like that it's machine readable, that it comes in a way that people can analyze it in what's called structured data, but also that the votes be in various categories. I think it was about a dozen separate categories that would be easier to understand how your fund manager is voting, and to easily assess across fund managers how they're voting on similar matters. So we have done that. I know it doesn't go all the way to the questioner's suggestion, but that is something that we've been taking up, and it would be terrific to hear from you in that role, about that role or about this broader topic area.
Well, I think that's right. I know the market has taken notice, Gary, with respect to these important changes to NPX. That was one of my complaints too when I was on the commission. I think a lot of time and money was spent on NPX. It wasn't nearly as understandable as it might have been, and your proposal seems to me quite a big step forward. I expect you'll be getting lots of comments from the market about that. In terms of BlackRock's, Stephen, the question we got, I'm just curious, do you have any initial reactions to the idea that an institutional investor is going to pass through to its underlying holders, or rather underlying institutions, the power or the authority to cast their vote? I mean, Gary, one thing that is arguably appealing about that is that you're allowing the people who are actually managing the underlying assets to cast the vote. On the other, there's a lot of logistical questions that this raises for the market. Should BlackRock pass along the proxy information? Does this give them unique conflicts because it gives them information about what their underlying holders think about the voting questions? Any reactions to the market development? I must tell you, here in New York, I think folks stood up and took notice when BlackRock made this change.
I want to study it more, and rather than react on a live interview set. But I think this, Rob, what we know from economics and what the courts have found is the vote matters. It is part of the economics. And investors get to choose whether to buy something, sell something, and vote something. Now, in a collective investment vehicle, when you bring together a fund manager that has hundreds, maybe even thousands of securities, and they're managing that on behalf of millions of investors, you're rightly raising there's a whole bunch of important and sometimes challenging technological issues about what you've just said. If you're managing a separate account and not, a fund manager is managing something just for you, Rob, then they might say to you, look, this is an important thing, the vote. How would you like us to vote? It's a separate account, it's just for you. It gets a little bit more, the details matter, and I wouldn't want to comment on something without knowing further on the details.
Well, that makes very good sense. And by the way, while I'm asking you about recent market developments and the proxy advisor rules and the like, I'm sure you'll say the same thing, but I can't help but ask you, Gary, what did you think of Glass Lewis's recent announcement that they'll be offering equity plan advisory services? Do you think that's going to lead to some conflicts in that space? Because I have to tell you, as someone who, as I say, was a dissenter from the proxy advisor rule, I thought it was oddly prescriptive for a Republican administration. It does seem to me that to the degree they're entering that commercial space, Glass Lewis might have some conflicts that might be worth disclosing. Any gut reactions to that market move? So
again, I hope you appreciate, I'll do this again, and for the next 4 of these questions you asked me about specific companies, I might shy away from talking about specific companies, projects, crypto tokens, whatever, and just sort of step back to more matters of general applicability. I think that the proxy advisor space, the credit rating space, there are some inherent conflicts. And this is one of the jobs. I mean, you had this job, Rob, or you were commissioner, but as 5 commissioners together, we grapple with sometimes highly concentrated market players like credit rating agencies or proxy advisors and the like, the 4 auditing firms. There's some that have highly concentrated market positions, and that might give them a circumstance from that concentrated circumstance And then there might be a conflict. They might be offering other services, as we saw credit rating agencies do, or accounting firms. And in the middle of Sarbanes-Oxley, a bill passed in 2002, tried to address some of those conflicts. So similarly here in proxy advisors, I'd say that's really an important issue that the commission has taken up in the past, and no doubt from time to time will address itself in the future.
Makes sense. Makes sense. By the way, we got a fascinating question related to the climate and human capital stuff we talked about. And Gary, I'll apologize in advance, but I can't help but ask you. Somebody asks, Chairman Gensler, what are the chances that you will be able to persuade your commission colleagues, Hester Peirce and Elad Roisman, to support advancing climate risk and human factor disclosure rules? This is a question from Mark Sheffer, reporter at Investment News. He says they and Republican lawmakers on Capitol Hill have expressed skepticism about whether disclosure rules address material matters. What do you think, Gary? How do you like your chances?
Look, I think that five-member commission, part of the really, I think, positive things that we have in the US is we bring 5 different people together, different perspectives, different outlooks, different staffs that are supporting each of us, and we try to do the people's business. And at the SEC, that's this 3-part mission I said earlier I was going to come back to. Investors, and in protecting those investors, capital formation on the other side, and the fair and orderly, efficient markets in the middle. Now, why am I saying this all to you? Because of course I'm not going to answer your question directly, but each commissioner is going to bring their perspective. I would say my perspective is that investors are making decisions based upon disclosures on climate risk, human capital. We at the SEC can play a positive role back to that 3-part mission. Investor protection, and investors get to decide. They get more consistent, comparable, decision useful information. How's it help on the capital formation side? Standardization also gives the companies a sense, aha, this is what I need to do, but not only that, this is what my competitors are saying in the same space, and I'm competing for capital in a more sort of fair and orderly, efficient way. That's the middle part of it. So I think this comes back to our 3-part mission. I've asked staff to serve something up. Each of my fellow commissioners will weigh in, we'll compromise where we can, we'll get the benefit of the commission structure. I look forward to that.
That makes good sense, and I always appreciated the opportunity to weigh in on those matters. Whether or not you get to yes, it's still a very fruitful set of conversations, and I certainly enjoyed them when I was on the commission.
Can I say something more, Rob? It is so fruitful. I mean, I'm privileged to do this my second time, and at our sibling agency, the Commodity Futures Trading Commission, as well. I found in those 5 years, I found in these 7 or what's it now, 6 months I've been in this job, it's so beneficial. The one-on-one bilaterals with Allison and Hester and Elad and Caroline, those one-on-one when we have closed door commission meetings on which is usually on enforcement matters. It's so beneficial. The open meeting that we've had, I mean, I think it's a strength of our regulatory system. I know not everybody agrees with me, but I really do think it is.
No, I think those of us who've been in those jobs, Gary, really do. Even when you can't get there, the conversations are extremely fruitful, and you really get a good sense, especially because you've got some terrific colleagues on that commission that I had the very great pleasure to serve with. Really insightful discussions. By the way, while we're talking about corporate governance and disclosure matters, let's talk about cybersecurity, shall we? There's been some debate over the last several years over whether cybersecurity breaches at public companies should be subject to tighter disclosure rules, given that relatively few companies that have been the subject of successful hacks promptly disclose that information to investors. Do you think moving forward on getting more transparency in that area, or maybe a different approach, Gary, like requiring cybersecurity expertise on public company boards, as some folks on Capitol Hill have suggested? Do you think that makes sense? Is it time to get some transparency or corporate governance protections around cyber at U.S. public companies?
I think that this is a critical area that we're challenged with, not just around public companies, but throughout our economy, throughout our official sector, that the attacks, the ransomware that goes on. And you wrote about this back in 2018, if I recall, about maybe it was in your second or third month in the job at the SEC, if I remember, Rob, but about the disclosure. And so I earlier mentioned, we've got a project on climate risk disclosure, project on the workforce, human capital, and thirdly, around cyber. And I've asked staff with regard to this is when there's an event, when somebody's been hacked and millions of names or maybe hundreds of millions of names and personal identifying information has been taken, when does the company disclose that? When do they decide it's what's called a current report called an 8K, and what guidance or rules we can make around event disclosure, whether it's ransomware, whether it's a hack that's taken millions of customers' names and disclosing. I think that we can benefit the investing public because, look, the economics show that this can change a price of security, price of fixed income or debt or equity security. So it's relevant to investors. We know that. So it's a question of when does it become material? When should it be disclosed? How should it be disclosed? And while there may be an ongoing also law enforcement and technological and computer science sort of side of it as well.
Makes sense. I'm sure the market will be paying close attention to that. I think this is really a challenge at the highest levels of any well-run boardroom. It's not easy. These folks are on the front lines of a constant war against American companies trying to hack into these systems, and they're doing the best that they can. The question is whether investors should have more insight into it. And I'm glad.
Can I mention? So there's really two projects at the SEC. One is on the company disclosure side. And another is on the investment management side. And there's two aspects of these projects. One is what we just talked about, reporting on cyber events of some sort. But there's also what I might call cyber hygiene. And this might be, in a sense, you could get your head around it more around investment management, but just ensuring that there's a various degree of cyber security, particularly when it relates to important confidential information that's held inside these organizations.
Makes sense. It sounds like important work is going on both on the issuer side and on the investment company side, Gary, and I'm sure the market will be delighted to hear that. Let's change gears now. We're fortunate to be joined by, hosted by the program on corporate compliance and enforcement here at NYU, and I'd be remiss not to ask you about some of the developments in enforcement at the SEC. In the short time since you've been chair, there have been some very, very exciting and important developments, in particular with respect to focusing staff on the need for admissions in connection with settlements under certain circumstances. And I wanted to ask you tonight about the prospect of individual defendant accountability in enforcement actions. I think that's been a long hoped for goal by almost all members of the commission. I think the idea that individuals should be held accountable when they commit securities fraud is a bipartisan one. But the devil's in the details, of course, Gary. Bringing those cases can be hard, and individual defendants tend to dig in even more than corporate ones. Tell me, is individual accountability something that the commission should be investing time and resources on as you think about the arc of your leadership of the organization over the coming years?
Well, I think accountability is a really important part of our law enforcement side there. SEC is an effective cop on the beat, a civil law enforcement cop on the beat. And that helps protect investors, but it also lowers the cost of capital. to the extent that we can properly hold companies and individuals accountable. And there's multiple tools to do that. Some of it is in the finding of facts and all the details of the finding of facts. But some of it, as you said, is also holding individuals accountable through bars, and that's not the bars you drink in. But, you know, a bar on for some period of time to be able to hold yourself out in this industry in certain ways. And so there's various tools in the toolkit. Head of enforcement Kabir Grewal has spoken about this recently. Sanjay Wadhwa's deputy have. And so I think that it's, as you said, it's a matter of trade-offs, but in the appropriate cases, it's really important.
Makes good sense. And I know that, as you say, enforcement policy is also at the SEC. It's led by the chair, and of course, your terrific director, Kabir Grewal, and his deputy, Sanjay, just extraordinary public servants. But of course, enforcement policy is also decided by the commission in closed commission.
Oh, absolutely. It's a 5-member commission.
That's right. So I know you'll be working hard to make sure that you've got support across the board on these important enforcement initiatives.
Rob, do you miss the big thick binders in the closed commission meetings? We can't say anything more, but do you?
I miss it all, Gary. And I have to say, I feel like you work on a really exceptional commission. You've got great colleagues in that room. And really, as you said earlier, one of the great pleasures of doing it is you get to work every day with the best securities lawyers in America. So I do miss that quite a bit. Let's talk a little bit, we're on the subject of corporate governance. Let's talk a little bit about another subject that I know has come across your desk. And that's the subject of the increasing prominence of dual class stock as a governance mechanism for US public companies. As you might know, Gary, while I was on the commission, BlackRock and the Council for Institutional Investors petitioned the stock exchanges here in the United States to adopt new rules governing dual class that would limit the degree to which companies could have that structure perpetually. And the stock exchanges, I understand, have considered those proposals, haven't yet moved forward on that basis. You know, I was struck when I learned about the events at Scholastic, the public company that is famous for the Harry Potter books, a dual class company where control of the firm was dictated by the will of its former CEO, who sadly passed away, and the control of the company was handed down by bequest. What do you think, Gary? You think that's an area where the SEC should be taking a look? What's your views on the use of dual class?
Rob, I thank you for the question. I might turn it back to you to ask you about the authorities and everything like that. But let me just say this. I grew up in the financial markets. I mean, neither of my parents went to college, but when my dad would ask, what us kids would think about if he bought 50 shares of this or 25 shares of that, it was never a lot. There was, by and large, just single class. And in fact, when I started at Goldman Sachs in the 1980s, the New York Stock Exchange, if I remember, their listing rules was just single class. Does that sound right by history? I mean, I might not just my memory right about this, Rob?
In the matter of the history, I think it wasn't until the 1980s takeover wars that management persuaded the stock exchanges to begin to permit the more widespread use of dual class.
Yeah, but I think that the economy worked well and shareholder democracy worked well with that. It was a little bit folklore at Goldman Sachs, but when Ford Motor was taken public, I think 1954, I might be mistaken, but in the early to mid 50s, they had two classes of stock, and Goldman Sachs said, no, the only way you can go public is if you kind of change that. And you can debate all sorts of things about the U.S. automobile industry and so forth, but I think that going to a single class of stock rather than that dual class stock, if I remember my history right, it worked out, well over the years. But again, I might have my history wrong. So they're sort of my early days in this, and I don't know what the stock exchanges will do with those filings, as you said.
Well, sure, of course, and the stock exchanges. Back, Gary, when you were still at Goldman, and when I was at Brad, stock exchanges were in the business of corporate governance, doing important work on that front, and they recently re-entered that fray. We just got another question from the audience that you might want to say a little bit about. We saw that NASDAQ offered a proposal related to board diversity, and I saw that the commission recently approved that proposal. The question we've got from our colleagues in the audience is, would the SEC consider a similar approach? The NASDAQ approach being one that involves sort of comply or explain regime, either have the required diversity or provide transparency to the market about why you don't. Is that something that you might think is appropriate beyond the NASDAQ context, Gary? So
I want to talk about the commission. We're looking at this potential role on workforce and human capital and diversity. That's a disclosure-based regime. Our authorities and our approach is embedded in the law, again, all the way back from the basic bargain, is investors get to decide. The SEC has a role in terms of ensuring that it's full and fair disclosure, consistency, comparability, and the like. That's our regime. So as we look at this, whether it's at the board level or the workforce level, Rob, and to your questioner, we're looking at something about disclosure. That's our regime. That's also the case as it relates to climate risk as well. Some other jurisdictions look at it differently, look at, as you say, comply or explain regimes, whether it's in climate or elsewhere. We're really a disclosure-based regime.
Makes sense. Makes sense. Let's talk a little bit about, given the questions that we're getting from the audience, we should ask a little bit about your views on various issues around market structure. And in particular, you've talked quite a bit recently about issues around payment for order flow and related questions. Tell us the market a little bit about how you think about those matters and what the status is of various commission efforts on those fronts. Let's talk first about those equity market structure considerations. And then, Gary, if you don't mind, I have to ask you a little bit about treasury market structure.
We're finally going to get to the meat of the evening, treasury market structure. So again, three-part mission: investors, capital formation, and then the market in the middle. And so we're spending a fair amount of time in our division of trading and markets, our division of economic risk and analysis, looking through how we can help this middle. And that's in the equity markets, it's in treasury markets, it's even in non-treasury fixed income, the corporate bond market, the mortgage market, and the like. We have $100+ trillion capital markets. About half of that, little less than half, are the equity markets that you see, covered on CNBC and elsewhere so actively. But the rest of those markets also matter so significantly. And if we can help the middle be more efficient, less costly, price financial assets better, that price discovery, better for investors, better for issuers over here. So the equity markets, yes, we're trying to take a close look. The last time equity market structure was really revised in a sort of a holistic way was 2005. You might know it. I'm sure Rob remembers it. Rule NMS on the national market structure, and 16 years later, so much has changed. Now, I would contend earlier that since 50 years since the Williams Act, a lot changed. But even in these 16 years, a lot has changed. And the events of this past January around the meme stocks and so forth reminded us about some of the current market structure, with half of the equity markets structure in January, to just quote from that, going not to the transparent, lit public exchanges, but going to wholesalers or the dark pool. So how are those orders competing with each other? Are the retail public getting the best out of these markets? Are they really getting best execution? How is it compared to the various other alternative market structures? So again, a lot of work, a lot of discussion going on. Public input also comes along in various meetings. So I'll leave it at that and turn back to you, Rob.
Well, thank you, Gary. And I have to, I wouldn't be doing my job if I didn't share this. Some folks in the audience are just asking, Chair Gensler, what are you going to do about payment for order flow? Is that something you can say much about tonight?
Well, all right. So let me just say, what we have now is a small handful of organizations, wholesalers that are buying the order flow from brokerage firms, but not all brokerage firms, but buying the order flow from brokerage firms. And so that if you place a retail order in the US and it's a market order, the vast majority goes to this small handful of concentrated market makers. And that doesn't necessarily compete with the broader market. And so we're taking a very close look at that. And part of it is this payment for order flow. Again, not all brokers pay or receive, I should say. Not all brokers receive it. Some do. Other jurisdictions like the UK, Canada, and Australia have actually banned it. Mm-hmm. What have we found in a number of enforcement cases? We found conflicts, specific conflicts in this area. And in essence, there is an inherent conflict when is a broker sending a trade off to really be the best execution, even if there's price improvement, but is it the best execution? Or is it in some algorithm sharing it with the two or three, parties that are paying for the order flow? So we're going to take a close look at that, but we're taking a look at the market structure around other aspects, something called the national best bid, best offer, and what's in that system and what's not in that system. The what's called rebates that are paid on the exchanges themselves. Even something that sounds as in the details as the increment between the bid and the offer, what's called the tick size. I mean, all of these little aspects are part of the market structure that was laid out in 2005. And 16 years later, I've said to this staff and the economists in Division of Economic Risk Analysis, what should we do here? And can we do better? It just feels a lot's changed in 16 years.
Sure. Well, look, while we're on the subject of equity market structure, and I'll come back to treasuries in a moment, but while we're talking about equity market structure, I'd be remiss, Gary, not to ask you about the report that came out from the commission just in the last, I think 24 or 36 hours on the events of last of January, and in particular trading in a couple of particular names. I guess the most famous one these days is GameStop. Interesting, the staff's analysis of those events. Maybe you can share with the audience. My guess is folks maybe haven't had a chance to go through it, a little bit about what the staff has found and what it tells us about the unusual events of those days in the market back in the spring.
Well, I mean, for those who are interested and don't have other things to read, it's on our website at sec.gov. But the report really analyzed the events. And you know the basic story. We tell the story through one meme stock, GameStop, that had gone from a little under $20 to $480 and back down below 100 and then back up. A lot of volatility. We tell a story where the investing public, about on an average day, about 10,000 individuals were participating. And then all of a sudden it rocketed up to, at the peak, I think 900,000 participating. We sort through some of the issues around the short selling, around the clearing houses, the basic plumbing of the markets and the like. And we also tell some background, I think in the second section, we tell a background about equity market structure as we know it as of January 2021, the issues around payment for order flow, and also how currently brokerage apps, and I would say other types of financial apps, are increasingly using digital analytics and marketing techniques, and to us, what sometimes people would call game-like features or gamification, to encourage us to trade more. So we sort of review that, and then the staff closes with 4 additional considerations, suggesting further work for the commission to consider
Now, Gary,
these 4 issues.
Sure, makes a lot of sense. I thought it was a very interesting report, and the terrific Matt Levine over at Bloomberg wrote it up this morning. And one thing that's interesting, Gary, is it doesn't.
What did Matt say? It's been a busy day.
Well, one of the things he points out is that not totally obvious that that the gamification-like aspects of new broker-dealer apps necessarily drove what we saw with GameStop. It certainly doesn't seem there was a ton of evidence in the report to that effect. And I guess my question for you, Gary, is, does it matter? I mean, might we still want to think about how to protect investors who are using these apps that encourage them to trade, whether or not that those dynamics are at the root of GameStop or not?
So, absolutely. The events of January, highly volatile, and the trading restrictions that happened on a fateful Friday in late January, where retail investors were shut out of the market, are really important, but they also brought us back to look at equity market structure and what's happening with new technologies. And on that point, we Americans every day, we're living with this, where our various apps, everything that's on these phones now and in our automobiles and on our Fitbits, are tracking us in different ways. And the data is remarkable for its ability to predict our behavior. And the use of a little bit of artificial intelligence, something called machine learning, can sort of predict, Rob, whether you're a good credit or not. I should ask you, Rob, do you charge your phone every night?
I try.
You try. Well, there's studies out of the US that if you charge your phone every night, you're a better consumer credit than if you don't.
Is that right?
So, Rob, I don't know, right?
Well,
all right, but
correlation's not causation. I think if I charge my phone, I'll still be the same credit in the morning that I was the night before. But hey, who knows?
Absolutely, but that's the point. That's the point. You're still the same credit, but statistically speaking, we can find things. So if statistically speaking, we could find that if I show you a blue color, you'll trade more. And if we show Ryan, who works with you, a green color, she'll trade more. Maybe they'll start statistically showing you blue colors and they'll show Ryan green colors. Now, why am I sharing this? The question is what are the applications maximizing for? Now, if a movie streaming app is maximizing for our viewership, yeah, I might see another rom-com, which I like or don't like, maybe. I like rom-coms, but it might be a rom-com I don't like. But if it's encouraging us to trade more so they can collect more payment for order flow, we might get lower returns. Or if a robo-advisor steers us into a higher fee product because they understand that, Rob, certain prompts and behavioral prompts will maximize, statistically speaking, maximize you to go into a higher margin product. When does it become a recommendation? When does it become investment advice? And even if it's not technically something that was contemplated years ago when we wrote the laws around investment advice and recommendations, what do we do about it now as a public policy matter when statistically speaking, the applications are maximizing not just on our returns, but a mix of their revenues, their data collection, and our returns. And that's a worthwhile public policy debate. That's something I think that's worthwhile, not just in finance. We're having those debates in other areas as well.
Makes sense. And I know the Office of the Investor Advocate, a terrific colleague in the Investor Advocate's office, recently made a statement along the lines that maybe the commission should be thinking about whether or not those deserve regulatory scrutiny, to the degree that ordinary investors are being encouraged to make trades that statistically don't make lots of sense. That might be something warranting scrutiny. And that brings me to a question that someone in the audience has asked, which is about, of course, regulation best interest, one of the principal projects of my former colleague on the commission, Chairman Jay Clayton. I'm wondering, Gary, folks in the audience are asking, what about regulation best interest might need to change? Is it fit for purpose? Is it up to the task of protecting the families that are getting advice, whether from a broker dealer or an investment advisor, about how to plan for their future? How are you thinking about regulation best interest in these early days of its life, Gary?
So I think best interest needs to mean best interest. Like I had earlier said, best execution should mean best execution. But let me stay on this. We have significant tools and examination and across the agency to try to ensure that regulation best interest means just that, that when a broker makes a recommendation, it's in your best interest, the investing public. And we're gonna do that which we can. In terms of these digital engagement practices, whether we call it gamification or it's using the predictive data analytics to steer you to trade more or to invest here or there, we put something out to public comment that was just asking the public questions. It's called a request for comment. That actually closed about 2 weeks ago. Based upon the comments that we received, I've asked staff to look at, should we update our rules for broker and on the other side, investment advisors under regulation best interest and elsewhere under our various marketing rules and so forth, under our various investment advisor rules, what might we do in this new digital data analytics period? So it's two things. We're gonna do what we can to basically get the best out of best interest. And secondly, we're also working on these digital engagement practices across the broker and the investment advisor space.
Sure. Well, that makes lots of sense. I have to say, Gary, I want to, based on some questions I've got from the audience, want to change gears back to an issue that was raised in your report.
And are we going about 4 more minutes? I'm just sort of checking because you.
You want to know how long you're on the hot seat, Gary?
Well, you said 6:45 and it's 6:41.
I might talk about 4 more years, but hey, that's just, anyway. Well,
no, I'm honored to be in the job for as many years as the president wants me, but I was just thinking about this interview.
No, for sure. We'll wrap up in just a minute or two. I do want to ask you, Gary, about 2 more matters. First, the academic research that's been probing this problem of short and distort.
You said short and what?
And distort, the problem that people are taking short positions, at the same time they're making false statements to harm a company's reputation, reversing those short positions and taking quick profits while investors can't know what the real underlying facts are. I'm wondering whether you're thinking anything about doing anything about the shorts in the market. Would you be interested in thinking through providing more disclosure on short positions, or maybe even pursuing those cases where investors are providing sort of distortive reports that are inconsistent with the underlying facts on the ground?
They're just very clear. Regardless of whether you're going short, meaning you're selling something you don't own, or going long, meaning buying something you don't yet, then you own it, and then distorting something. Our laws, our robust and broad laws at the SEC, are to protect the investing public against fraudulent, manipulative, deceptive acts, whether it's going long or going short. So the distort side of it, our agency is trying to be a vigorous cop on the beat. If you've got something that you think is going on that's something like that, come on in, tips and complaints, whistleblowers, the like. Really, it's a big part of our enforcement enforcement agenda and sourcing from the public if you have something there. Let me go to the question about short selling. We do have a mandate from Congress to have additional disclosure around short selling. In the reforms after the financial crisis, Congress put in place and didn't just give us the authority, but mandated that we have disclosures around short selling. And so I do believe that we should take that up. Congress also mandated that we have disclosure, public disclosure around stock loan. And stock loan, it's actually the words in the statute is the lending and borrowing of securities. So to use the term of the statute, I think it was section 984 of Dodd-Frank. So those two areas, mandates around securities lending and borrowing, mandate about short selling. I've asked staff, it's to fulfill the congressional mandate. I think we will definitely take that up at the commission. And if there's the support of the commission, try to get it out to the public and finish it.
Makes sense, Gary. And my audience won't forgive me if I don't try to get one more question before we let you go for the night. We are so grateful that you spent this time. And this is an audience question, Gary. So so don't blame me. But one of our colleagues in the audience,
Rob, why would I ever do that?
One of our colleagues in the audience has noticed that this week the Senate Appropriations Committee released its budget for the SEC, and there's a noticeable omission. The rider prohibiting the commission from making a rule requiring disclosure of corporate spending of shareholder money on politics has been removed from the draft bill. In the interest of full disclosure, so to speak, I should say that I was the author of a petition to require that kind of transparency.
I think that petition went on to get like 1.2 million signatures, but maybe I'm off. You probably, but you keep a current count probably, Rob.
Yeah, no, who's counting? So a question, Gary, that we've been asking the audience is, if the appropriations bill comes out clean without that rider, is that something the SEC should give some thought to? That is providing some transparency to investors as to how their money is spent on politics.
Look, two things. One, it's up to Congress, but two, just as we've focused on other disclosure initiatives, climate risk disclosure, human capital, potentially board diversity, cyber, it's about investors. To the extent that you look across the markets and investors want disclosure, climate, human capital, board diversity, or yes, in this case, in terms of political spending, we, the SEC, have a role. We have a role to help those investors bring some consistency and comparability. So of course, I'll wait. I'll see what Congress does, but I didn't know that. I thank you for the update on the Senate Appropriations Committee.
Well, no, Gary, thank you. And we're unfortunately out of time. We've got hundreds of questions from hundreds of folks in the audience, Gary, who I know are grateful along with.
Did our viewership go up during this or did it go down?
I don't know. I'll have to ask the predictive analytics team. I'll get back to you.
I was always wondering when I was teaching up at MIT and everything, like, did I end the lecture with this? Once we went to Zoom and look, I would say this to all the listeners. I mean, we still live in unusual times and hopefully we can all look back and laugh, but I know many of us, including myself, have lost loved ones to COVID. It's still very much part of our daily lives, our economic lives, our family lives, our health and safety. So stay safe, be well. We at the SEC are still on voluntary remote. I just can't believe the 4,500 people at the SEC plus couple thousand contractors in the IT area just for 20 months have pulled this off. And so I also just note to all the people at NYU and the lawyers listening, I mean, a big applause to the SEC staff to pull this off for 20 months. It's really remarkable. I thank you, Rob, for hosting me, Ed and Jennifer and so forth. I hope this was lively for your audience.
Oh, well, it certainly was, Gary. Thank you for your extraordinary service and for your insightful commentary tonight. Folks, on behalf of my co-director, Ed Rock, and Jennifer Arlen of the Program on Corporate Compliance and Enforcement, thanks so much for joining us here at NYU tonight. We look forward to continuing these conversations with cutting edge folks thinking through these issues in the marketplace, including, of course, the chair of the SEC, Gary Gensler. For those of you interested in more from the SEC, I'd be remiss not to point out that the Program on Corporate Compliance and Enforcement on November 5th will be hosting a program entitled The Next Wave of Corporate Enforcement, featuring none other than Gurbir Grewal, the Director of Enforcement serving under Chair Gensler at the SEC. Gary, thanks so much for your time and insight this evening. We're very grateful for both and of course for your service. Thanks all for joining us. And Gary, looking forward to the next conversation. Take care.